Hello friends, and welcome back to another informative video. So today we are going to talk about what affects us in the state of Arizona. So the Arizona legislature has significantly expanded and strengthened the state's data breach notification law. So the legislation was signed by Arizona Governor Doug Ducey on April 11, 2018, so just a few days ago. So below we discuss the most notable changes. The expanded definition of the personal information, and the Arizona prior law narrowly defined personal information as an individual's first name or first initial in combination with the individual's social security, driver license, or operating identification license, financial account, credit card number, combination with any required security code, access code, or passcode that would permit access to an account. So that is all confidential information and protected information. So the new law significantly expands that definition to include the following data elements: a private key that is unique to an individual and is used to authenticate or sign in an electronic record, or an individual's health insurance identification number, information about an individual, medical or mental health treatment or diagnosis by a healthcare professional, a passport number, a taxpayer identification number, or an entity protection personal identification number issued by the IRS, or unique biometric data generated from a measurement or analysis of a human body characteristics to authenticate an individual when the individual accesses an online account. So all that is considered protected information. So whereas Arizona prior definition was one of the narrowest in the country, so in the new definition, it's one of the most expansive. So extension to online account login information. The law also now requires notification if there is a breach of an individual's username or email address in combination with a password or security question and answer. So that allows access to an online account if the breach is limited to the information and does not include any other data elements. So notice may be provided in an electronic or other form that requires the affected individuals to change their passwords and security. So the questions and answers that directs them to change their passwords and the security questions and answers for any other online accounts that use the same information. So you have 45 days deadline to provide notice. So Arizona has joined the growing number of states that have set a specific time frame for when the notice of the data breach be provided to the affected individual. So Arizona law previously required that notice must be provided in the most expedient manner possible without unreasonable delay. However, the new law requires that the notice be provided within 45 days after determination that the security breach has occurred. The statute defines security system unauthorized acquisition of unauthorized access that materially compromises the security of confidentiality of an unencrypted and unredacted computerized personal information maintained as part of the database of personal information regarding multiple individuals. Notably, the amended statute provides that the notice does not need to be provided if the person, an independent third-party forensic auditor, or law enforcement agency determines after a reasonable investigation that a security system breach has not resulted in or is not reasonably likely to result in substantial economic loss to affected individuals. The prior law also contained a substantial economic loss required but did not specify that a third-party forensic auditor or a law enforcement agent could make that determination. So the contents of the notice, the new law specifies that the notice must contain the approximate date of the breach, a brief description of the personal information included in the breach, and the contact information for the three largest nationwide consumer reporting agencies and the Federal Trade Commission. That change is consistent with other recently amended enacted statutes with the similar requirements. Notice to the consumer, guys, reporting agencies, and Attorney General. So if the breach requires notification to more than 1,000 individuals, notice also now must be provided to the three largest nationwide consumer reporting agencies and the Arizona Attorney General. On top of that, so the increased civil penalties. So the Attorney General retains exclusive authority to enforce willful and knowing violations of the statute, and the new law significantly increased the potential penalty. So under prior law, the Attorney General could seek a $10,000 civil penalty per breach of the security system or series of breaches for similar nature. The new law provides that the Attorney Generals may seek a civil penalty not to exceed the lesser of the $10,000 per affected individual or the total amount of the economic loss sustained by the affected individuals, with a maximum civil penalty from a breach of a series of related breaches of $500,000. That will put you out of business, guys. So this is something very serious. And so into some entities that the business in Arizona and collect personal information from state residents would take note of these changes and analyze whether their existing information security controls are sufficient to protect against a data breach. Well, that's where you guys have to contact SHREDOCS CSR Readiness Toolkit. I've said it once and twice and 3 times. You need to sign up. Trying to do this on your own, trying to file a breach, it's just very confusing. So for only $19.95 a month, your business has the peace of mind, and you're in compliance using your self-assessment and having policies and procedures in place. So if you're really to take the next step, sign in, and thanks for listening.